offense of police officer assault, resist, or obstruct, in that you did assault, batter, wound, resist, obstruct, oppose, or endanger Officer Daniel Gertz, a police officer of the Gaylord City Police Department, who you knew or had reason to know was performing your duties. That is a felony offense that has a maximum penalty of 2 years and or a $2,000 fine. Do you understand the name of that offense, ma'am?
I'm not really sure what you're saying, but kind of. I have a resisting arrest?
Yes, that's count
Right.
1. As a maximum penalty of 2 years and $2,000. Do you understand that?
Yeah.
Count 2 is the same kind of charge, resisting arrest. The name of it's called police officer assaulting, resisting, or obstructing. It says that you did assault, batter, wound, resist, obstruct, oppose, or endanger Officer Jacob Depew, a police officer of the Gaylord City Police Department, who you knew or had reason to know was performing his duties. That also is a felony offense with a 2-year and or $2,000 maximum penalty. Do you understand the name of this charge in count 2 is also police officer resisting? And you also understand that that has a 2-year, $2,000 maximum penalty? All right. In addition to that penalty, there's also a habitual offender notice being sent called fourth offense notice, which enhances the penalty. It says that you did on or about October the 13th of 2020 were convicted of the offense of resisting and obstructing police in the 46th Circuit Court of Otsego County. On or about February the 5th of 2019, you were convicted of resisting and obstructing police in the 46th Circuit Court for Otsego County. And on or about February 5th of 2019, you were convicted of the offense of attempted arson preparation to burn a building, also in the 46th Circuit Court. And because of that, the underlying 2 offenses have a maximum penalty of, Ms. Brucker, this says life, but I don't know that is it 3rd offense that doubles it, or is it 4th offense that mandates the life sentence? Excuse me, the 25-year sentence.
I'm sorry. I think it should be 15 years, but let me double check that. I might have selected the wrong prompt when I did that. I'm sorry. If I could just have 1 second.
Yep, go ahead. Ms. Brink, she's going to check to see if the information that I have on my paper here is accurate.
All right.
It would be 15 years, Judge, and I'll get that corrected.
All right, thank you. So Ms. Brink, with the habitual offender notice, the maximum penalty is now 15 years in prison. Do you understand that?
Yeah.
Count 3 alleges that you did commit the offense of retail fraud in the 2nd degree. That is, that in a store or its immediate vicinity, that is Walmart, when it was open to the public, you did steal property of the store that was offered for sale at a price of $200 or more, but less than $1,000. That's a misdemeanor offense. It has a maximum penalty of 1 year and or $2,000, up to 3 times the value of the property that was stolen. You understand the name of the offense to be retail fraud, that is shoplifting?
Yeah.
You understand the maximum penalty is up to 1 year in jail and or a $2,000 fine?
Okay.
All right. Right now you have certain rights. I want to tell you what those are. You have the right to plead guilty, not guilty, or no contest, or excuse me, stand mute. You have the right to have a trial by a judge or by a jury, and you have the right to have an attorney. As to your trial rights, you have the right to see, hear, and question all the witnesses. You have the right to present your own witnesses and evidence and get an order from the court called a subpoena to require those witnesses to appear and testify. You have the right to testify yourself, or you could remain silent. And if you chose to remain silent, that silence could not be used against you. You also have the right to be presumed innocent until proven guilty beyond a reasonable doubt, and to have that burden of proof remain with the prosecutor at all times. Finally, at trial, you'd have the right to automatically appeal if you wanted to any error that occurred. However, if you enter a plea, you'd be
Oh, he
limited to
loves us.
asking the court for permission
not
to
worried
appeal,
about
and
it.
that might not be granted. You understand the rights that I've just given to you?
Yeah,
You have any questions about any of those rights?
no.
All right. Mr. Brown, have you talked to Ms. Brink about court-appointed counsel?
I was not really able to get that far, Your Honor, but I am going to say that she is. I currently represent her on a few other cases.
All right. Ms. Brink, I'm going to appoint an attorney for you. In the past, we've dealt with each other and you've been eligible for court-appointed counsel in the past. So I'm going to do that now. Mr. Gilo is going to assign the specific attorney. It may be Mr. Brown, it may be somebody else. But right now I'm going to enter a not guilty plea on your behalf in order to protect your rights until you have a chance to speak with your attorney. Because you're charged with felonies, I'm also going to set some court hearings on a quick basis so that those protect your rights as well. The first one is called a probable cause conference. That's a chance for your lawyer and the prosecutor to discuss the case quickly to try to resolve it. That'll happen within the next 7 days. We'll also set a preliminary examination date within the next 21 days. That's a chance, that's an opportunity for the prosecutor to prove in court a small amount of evidence called probable cause that you committed the crimes that you've been charged with. Do you have any questions as to the hearing dates that we just talked about?
Oh, I didn't really hear you though.
Do you want me to explain what a probable cause conference and a preliminary examination date is?
Oh, no. I get it. I thought you were setting
Okay.
dates, like giving me dates.
Nope, not yet. All right, what I'm going to do next, Ms. Brink, is I'm going to ask the lawyers about bond, and then I'm going to give you a chance to tell me what you want me to hear about bond as well. So, Ms. Bruker, could you, any thoughts on bond?
Ms. Brink is currently on bond for a trespass charge that we're set
No, I'm
for.
not. There was no bond set.
Okay,
Ms. Brink, she gets to talk, and then you'll have a chance to talk afterwards. So I'll listen to you what you want to say, but you got to let her talk without interrupting
No, I'm not. I love it. I just love it.
here, please.
and she's set for an upcoming trial in that case. She was recently convicted of assault and battery back in February. And she does have a history of felonies and misdemeanors on her record that are assaultive as well. I would ask for the standard terms and conditions of bond, including that she not re-enter the Walmart store. I would ask for the court to order that she report to community corrections. I'd ask for the court to order that she follow through with any of her community mental health appointments and treatments. It appears that this crime, as well as her trespass charge, are probably related to some of her mental health issues. So I wrote on the bond sheet a $10,000, 10% bond. I'll leave that to the court's discretion. When Ms. Brink is out in public, she violates the law, she fights with police. We need to make sure that she's safe and the public are safe. But I also recognize that she does need her mental health treatment.
Mr. Brown, your thoughts?
Your Honor, as the court stated, is familiar with Ms. Brink. She does suffer from some mental health issues that she's seeing CMH for. I would ask the court to take that into consideration when setting a bond if she has appointments coming up, but definitely don't want her to miss that. If she's taking any kind of medications, I want to make sure that she is getting the medications that she needs. Other than that, Your Honor, I would leave this up to the court's discretion.
All right, Ms. Brink, this is your chance to tell me what it is that you want me to know about your bond. I would simply caution you, if you don't make any statements about the underlying facts of this case, because we're recording this and it could be used against you later. Is there anything else that you want me to know about bond?
Well, I have no money because I went to prison once already and it destroyed my life and I have no way of working, so I have no money. So that should be taken into consideration. I'm pregnant, so I'm gonna need OBGYN care. And when I left the hospital just recently, I told them, please make my appointment for the next day when I get discharged because I cannot wait that long without seeing someone. I go crazy in the public because I have been to prison and I don't understand people anymore. And they didn't do that. So I went nuts because I found out I was pregnant. So all of that needs to be taken into consideration. $10,000 isn't too bad, but I'm not gonna be able to make bond, so it doesn't matter. You're gonna keep me in jail and probably send me to prison for this anyway.
Have you been to see a doctor yet about your pregnancy?
No, it's too early to even get a positive pregnancy test.
Are you currently working with anybody from community mental health on your treatment?
Yes, I am. Dr. Gurman is my doctor, and I'm supposed to be getting hooked up with ACT as well. They were gonna help me and like get a plate because I'm homeless. And because my parents have dementia, they don't understand that I'm homeless. They won't take me into their house. They keep calling the police on me because they don't recognize me anymore because I went to prison.
All right, so do you think it would be a good idea for you to start working with Dr. Gurman again?
Well, I have a complaint with CMH filed against him for not being fair and violating my rights. So I prefer a different doctor. I've mentioned that to the court once. That hasn't been respected at all. But I need to work with ACT and CMH because I have depression, anxiety, and I don't know.
All right, are you
Depression
taking any
and
medic?
anxiety.
All right, thank you. Are you taking any medications right now?
No, I'm not because I'm pregnant and I wanted to make sure that it's not going to negatively affect this pregnancy. Even though you're going to take this child away from me. I'm not interested in hurting this child.
Good, I'm glad to hear that. All right,
Yes. It's probably best for me to stay in jail for as long as possible because I have nowhere to go. So when I get out, I'm going to go back to violating the law so I can come back to jail.
Well,
No, that's the fact, Larry. I went to prison. I cannot work. Nowhere will hire me. I have no money. I'm stealing food like an idiot.
okay, I don't want you to go into that, please.
Well, I'm just saying. He's asking questions. I'm telling him what needs to be considered with my bond. A PR bond would be nice so I can go look for work and take care of a baby, but that's not going to happen. I'm realistic.
thank you, Ms. Brink. That's all the information I need right now.
Are you going to set my bond?
I'm thinking about that right now. So yes, ma'am, I am.
Oh,
Just give me a
okay.
minute.
Sorry,
Just
you
give me
didn't
a
say
minute.
anything, so.
No, that's all right. Yep, I understand.
I'm half nuts too because I haven't seen or talked to my children that already exist in a very long time. So I can't help it. You know, I really can't. I don't even understand that I'm breaking the law. My parents are nuts. I'm getting no support out here.
Well, we're gonna try to get somebody to come into the jail and help you with that. All right, we are gonna set bond at $10,000, 10%, cash surety or 10%. The reason for that is her past history of violent behaviors, assault and resisting and obstructing. There does need to be some amount of bond that protects the public. However, because she has a mental illness, it also needs to have some treatment part of that as well. So the requirements, Ms. Brink, are that you appear for any scheduled court dates, that you abide by the judgment of the court, that you not leave the state of Michigan without the permission of the court, that you not commit any crime while released, that you immediately notify the court in writing of any change of address or telephone number. You may not use any alcohol, marijuana, or illegal controlled substances while out on bond. You must participate in a substance abuse testing or monitoring program through community corrections. And you must comply with all community mental health treatment programs. And that includes doctor's appointments and medication as prescribed. You also may not enter the Walmart in Gaylord, and you must contact community corrections upon your release. You have any questions about the bond?
No,
Ms.
I'm
Brink?
not gonna be able to make one.
Well, I set it at a point, you'd have to post $1,000. If you are able to, then you need to do what CMH tells you to do. Deputy, I asked that you guys call CMH and ask if they can send somebody to the jail to evaluate her and see if they can get her on some prescription medication.
Yes, sir. Can we make an OB? Well, whatever. I'll just tell them and they'll work with me on that way.
All right, that's all for today. Thank you, Deputy.
Okay.
Hold on a second.
And finally, we have the
Oh man, Alyssa just sent me that. All right, we'll go to
with
this one then.
Ms. Daybell. So we had provided her with the documentation for Kay Woodcock in the amount of $8,949.52 prior to, or at the time of the sentencing. So
Were there
I'm
any-
not sure if she'll stipulate to that.
That was the only request so far?
So far, the request for Brandon Boudreau at this time, he's still trying to get that together. So we would just ask that remain open. And when we have those documents, we'll provide them to Ms. Daybell and then set a hearing so we can see if she'll stipulate or not.
All right, so
Oh yes, crazy is back. It's a restitution hearing.
I'll turn to Ms. Daybell. What's your position on the restitution request?
Because I haven't received anything from Mr. Boudreau, also, the documents I have received from Ms. K are insufficient on their face. The defense is requesting that the state would give the defense an accounting of the stipulation that has already been given to the victims in these cases by the state, so that we can accurately review the receipts that have been given to us, and then we'll be able to go from that point.
Judge, I actually have no idea what Ms. Daybell just said. She was provided with copies of all of the receipts as well as an accounting on an Excel spreadsheet. So if she doesn't agree to that, then we would need to set a hearing.
All right, is there something?
What I'm asking for is for the state to also give what they have already reimbursed the victims as witnesses when they came. It's very confusing, the receipts that we have received, what they were already reimbursed for. So in order to have a hearing, I would need those disclosed to the defense as soon as possible.
All right, I haven't seen any of these documents. Is the defendant talking about there's some things that are is the county attorney's office seeking restitution from their victim compensation fund?
We did not provide a request for that, no.
Okay, so I guess what if the victim, if Kay Woodcock is requesting certain amounts of money that she spent and no one's requesting money that the victim's compensation fund may have given to her, why would that be relevant for restitution hearing? I'm asking you, Ms. Vallow.
Oh, you're asking me?
Yeah.
So
If no one's requesting reimbursement for money that the Maricopa County Attorney's Office Victim Compensation Fund gave any witnesses or anything, that's not something that we're talking about for a restitution hearing.
Well, that's what the defense doesn't know. The defense doesn't know what's been compensated and what hasn't been compensated. So on some of the actual receipts, there are saying 3 victims stayed at this hotel room or 3 next of kin stayed at this hotel room. So is Ms. K asking for those things to be reimbursed to her and she's going to cut everybody a check, or how is that supposed to work? So I'm asking for some clarification on what has been compensated, what hasn't been compensated, and what she's actually asking for.
Okay, I think I need to just set it for a hearing, and those are questions you can ask. She would need to testify, I would suppose, for any money that she expended. So can we do a virtual restitution hearing Friday, October 3rd at 9:30 a.m., 2 weeks from today?
Judge, I'm not sure. Kay is not on the line right now, so I would have to check with her after this. I do have something in the morning until about 11 o'clock, so I am free in the
You know, seeing Lori here today, it makes me realize I didn't miss her at all.
afternoon if Kay Woodcock is.
Is there, since we have everyone here now, is there a way we could recess for a couple minutes and you could check?
We can attempt to reach her.
Or yeah, I could do also October 3rd at 1 p.m.
So for me, 1 p.m. would work. I mean, we could set it then. We can reach out to Kay, and if it doesn't work, we can let the court know. I mean, obviously, it's more difficult with Ms. Daybell, not easily reached, but I'm not sure how else to do that.
And again, everyone, I would expect everyone just to appear virtually. The state would need to mark. I think the easiest way to do it is any receipts or documentation that you want me to consider would need to be marked just as one packet and a copy sent to Ms. Vallow. Let's do an alternative just in case that witness isn't available. So first choice will be the 3rd at 1 p.m. Second choice, how about the 10th, October 10th at 9:30 a.m.?
That works for the state as well.
All right, so we're going to assume that it's October 3rd at 1 p.m. unless we hear otherwise by Monday. If we do hear something, we'll cut another minute entry so that everyone's on notice that it'll be the 10th at 9:30 a.m.
Okay.
Your Honor,
Right.
if those documents could be emailed to our paralegal here at PWCC, her name is Rachel Cheney. I wasn't going to say your first name, Miss Cheney. Then that could be expedited. So I could get that as soon as
They are
possible.
the same documents we previously disclosed. We can re-email them if maybe Mr. Abernathy can send us the email, but they're the exact same documents we previously disclosed.
And I'm going to need them again for review. I wasn't able to bring those with me.
I, out of an abundance of caution, I would just ask you to send another copy in the exact, order that you would be presenting it as an exhibit. So when we're referring to it virtually, everyone's literally on the same page at the same time. So Mr. Abernathy, are you willing to accept that email and get it forwarded to Ms. Daybell?
Yes, Judge. I currently have no contact information from Ms. Daybell. Obviously, this case is on appeal, and we have an appeal attorney assigned to it. I think he's in the process of trying to establish direct communications with Ms. Daybell, but I'm not sure if that's actually been accomplished at this point. Obviously, we would need like a legal privileged line to be set up. So I haven't had a word on that. So I'm not sure. I mean, October 3rd is coming up pretty soon. That might be a little premature. I also don't know how we can do a virtual hearing with advisory council. I don't have any way to communicate directly with Ms. Daybell, that's going to be a privileged.
Okay. Well, you're advisory council, so you don't take an active role.
Well,
Ms. Daybell,
sorry, Judge, I could take an active role if Ms. Daybell has a question in the middle of this hearing, then we're not going to be able to talk and we're going to have to reset the hearing. So we're going to have to establish some way that she can communicate with me directly in order to not have to reset this in the middle of the hearing.
Judge, maybe
okay,
to ensure that, I'm sorry, Judge.
Go ahead.
I was thinking to ensure that Ms. Daybell has time to speak with her advisory council and that they are able to set up a way to communicate prior to the hearing so that they can discuss that. As much as I don't want to push it back, I think it might be better if we allowed them some time to discuss the hearing and whether or not she needs to stipulate to anything. As we've indicated, there is no victim compensation that's been paid out. It's just the documents that exist. So maybe they can go over those with her and lessen the time of whatever this hearing is about.
Well, I guess I'm a little frustrated that Ms. Daybell, the defendants had this information for 2 months and there have been no conversations apparently or contact.
And
So
Judge, just to avoid some frustration with the court, there were contact, or there were conversations, but since Ms. Daybell has been transported back to Idaho, that communication has ceased. So at this point, I haven't been able to communicate her currently as to what the status of any of this is. I know based on previous conversations, there are some issues that we need to address, and I do need to talk to Ms. Daybell about regarding the actual documents that were sent. I am happy to basically send a copy of those. I mean, I'm happy to do that if Ms. K will send those to me. It sounds like they're the same ones. So I will forward those to Ms. Daybell in Idaho so she can review those. Sounds like she didn't get to transport those with her.
okay, so that's fine. We'll do a little more time to make sure that documentation gets forwarded in the format that we would anticipate it to be marked as an exhibit. So let's do. All right, is advisory council or Ms. K in trial the middle of October?
I'm not sure.
That's
I don't know what.
sorry, that's at the prison.
I think what I'm asking is, does it need to be on should we just shoot for Fridays?
I think Fridays are probably better, Judge.
Okay, is 4 weeks enough? Friday, October 17, 1 p.m. Oh, wait, I've got a block, 1:30 p.m.
I'm sorry, Judge, did I miss the date?
Friday, October 17 would be 4 weeks from today.
Okay, that's fine with me, Judge. If for some reason I can't establish contact with Ms. Daybell in that time frame or any reasonable time frame, I will let the court know.
And Judge, should we come up with any reason why Ms. Woodcock is not available, we'll also advise court.
He emailed us the paralegals. If you want me to put it in the chat for council, the paralegal in Idaho.
Oh, I'm being told my JA has the paralegal's email in Idaho that those documents can be forwarded to, and the courtroom assistant's gonna put it in the chat, Mr. Abernathy.
Okay, thank you.
Your Honor, I also have, I'm sorry to interrupt. I also have all the information too. I've been dealing with the paralegal. I even have been talking to the warden,
Okay.
trying to get things set up for to be able to speak to Ms. Daybell.
Okay. All right. Is it in the chat?
Yes.
Okay, it's in the chat. Copy that info down. Mr. White sounds like he has it. Unless there's some sort of settlement of the restitution issue, I'll expect to see everyone virtually October 17 at 1:30. Again, if that doesn't work for the state's witness, please let us know sooner rather than later.
Okay. And Judge, can I just email the document that we'll be using, the exhibit, to your clerk? Or I'm not sure who, do you have a clerk there?
We're not going to know who the clerk's going to be until a few days before, but it will reach out to the parties, and in addition to the state, if the defense has an exhibit they want marked, we'll let you know who to send that to.
Okay, thank you.
All right, anything else?
Nothing from the state, Your Honor.
Your
From the
Honor,
defense.
since we're gonna be having this 4 weeks, is it possible, I don't know if the state knows, but is it possible to have the receipts from Brandon so that we can, Mr. Boudreau, so that we can do that all at once?
That's not going to be completed in 4 weeks.
All right, so may have other restitution hearings in the future. I don't know. All right, we'll be at recess. We'll see everyone October 17, 1:30. Thank you.
Thank you.
And I just need a, they had proper, all right. And finally, we have the Yell Curtis matter. This is number 2.
Okay. Big shout out to Law Nerds Unite. I tried to run this a second ago. They pulled the video. Of course, Zach had it. Midstream. Alyssa sent this to me after I already started. Then I tried it. I showed it for 3 seconds and it cut off. But Zach had it and sent it to me. Let's see what's going on.
250000285. Ms. Yell, I appreciate your patience. I know you've been sitting here for a while. The other party was in another courtroom and we had to transfer them over, which can sometimes be a slow process. And good morning as well to Ms. Rose Curtis. Thank you both for being here today. Now, I see that both parties are here, so we can proceed. I'm going to ask first, I'm going to swear parties in. Ms. Yell, would you be so kind as to raise your right hand? Do you swear or affirm that the testimony you provide at today's hearing will be the truth, the whole truth, and nothing but the truth? And Ms. Yell, I can't hear you.
I do.
There we go. Perfect. All right, Ms. Curtis,
Yeah.
can you raise your right hand?
Yes, Your Honor.
Do you swear or affirm that the testimony you provide at today's hearing will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right. Excellent. You can put your hand down. I'll consider you both sworn in and speaking under oath, and thus affected by the expectations of honesty. Bear with me. All right. Give me a few moments. I'm going to need a couple of minutes to review some of the paperwork in this. All right. I've had a chance to review this. I'll start with Ms. Yell. You are the petitioner in this matter. What would you like me to know about this?
That it's had a severe impact on my state, my mental and emotional state, and I feel for my safety in being in my own home. And I was just going to ask, Your Honor, if I could have some more additional time to submit my medical records and possibly ask for a continuance on this matter, because I have other supporting evidence that I wanted to add to the case.
I bet she's got spreadsheets. I'm just saying.
All right. Ms. Curtis, do you have any objection to a continuance in this matter, simply setting it over?
Yeah, actually I do. I'm taking time out of my work. I work 2 jobs. I'm having to take time out just to have this done. I wasn't even served correctly. I wasn't even served at all. My daughter answered the door and then she told the lady that she wasn't me. Closed the door. The lady dropped the paperwork. This is on the 17th. Dropped the paperwork on my porch, I guess. I don't have time to deal with any of this nonsense. Like, I don't know if you guys, I turned in paper.
Yeah, it's close. That depends on the jurisdiction. That could qualify as substitute service.
Or emailed all my paperwork, whatever, to the email address. I really.
Ma'am, I'll start off by saying I understand that you did not have proper service in this matter. However, you did appear today. So I know that you were aware of this hearing. That's about all I do to service. As to emails, there's quite a bit in this file. I've had a chance to review some of it, but today's hearing it's reasonable to, well, I'm going to go back and say this. It's reasonable to refuse to object to a continuance in this matter. Ms. Yell, I need some additional information. You scheduled this hearing. You've had an opportunity to file paperwork. It appears that the other party is here and is taking time out. Is there a reason that we can't, that you need to submit medical evidence in this matter?
Yeah, I was going to get some medical from CMAR from my counseling to show that I have had to go to continuing counseling over this matter for PTSD, and that I do feel afraid and worry all the time, Your Honor. And I really feel confused on a daily basis. I can't concentrate. And I just feel afraid because the respondent keeps sending her boyfriend over to my house. And over the weekend, there was numerous occasions where she had sent her boyfriend over to my boyfriend's house. And then he came over here and told me that the respondent was
I'm going to stop you there.
him, and that if
Ma'am, I'm going to cut you off there.
Okay. All right. All right.
I'm asking, none of the claims that you have entered as part of this involve an assault. Is there any reason that I need to be aware of medical things? I understand that you're frustrated, that you may be dealing with frustrations, you may be dealing with some degree of anxiety, but I don't see anything in here that is relevant to whether or not this took place. So the question of medical information is, I need to know, is there a medical reason that you cannot continue this hearing, or have you been assaulted as part of this process?
Oh, no, I haven't been assaulted. No.
Okay.
I would just like to have some continuance so I could submit.
All right, well, ma'am, I hear your request for continuance and I'm going to deny it. You've had an opportunity to bring your case. The other party is here. We're moving forward today. So, ma'am, I need you to tell me, I've had a chance to review the file, but in your own words, what is taking place here?
I feel like the respondent has been keeping me under observation in my home, and this dates back to 2023. And I've had continuous problems with her, and I've done nothing to her to make her feel a certain way. I'm very polite and respectful, but she's been making me feel afraid in my home. She's been harassing me and stealing my internet and my Wi-Fi. And I've had to, I
Why
might have another video.
All right, someone has joined in under the
I'm sorry about that. I don't know why my video went out.
Sir, are you?
Oh, okay.
You're not. You don't appear to be a party in this matter. But may I have your name?
Dan Trail Fogel.
All right.
I can't get my video.
Are you here for the civil protection order calendar, sir?
No, sir. I didn't know which link to use.
All right. I think you're in the wrong courtroom. Can I have your full name again one more time?
All right. Dan Trail Fogel.
All right.
All right.
I can't get my video up.
Mr. Fogel, we'll send you a link in the chat, but you're supposed to be in courtroom 2.
Okay, thank you.
Absolutely. All right. Ms. Yell, please continue. I see that your video is turned off, but you're welcome to continue. Is there anything else you'd like me to consider?
Yeah. Yeah, Your Honor, basically the respondent has been hacking into my Wi-Fi and then turning off my computer somehow by remote access. And I don't know how the hacking's done, but this has been a continuous thing since 2023. And I've had to do everything to secure my network and my passwords. And it's just been a complete nightmare for me to keep continuously to do this. It costs me money. I've already installed 3 cameras around my home. I doubly lock my doors because the respondent sends her boyfriend over to my house so many times that I feel afraid on a daily basis. I'm so confused. I can't think straight. Also, Your Honor, the respondent has been calling names every day. She said she hates me. Her words were, "I hate that effing bitch." And then she tells me to F you every day. And then I've provided documentation with that in one of my declarations. I have a timeline of that I submitted of each time that she's called names. And this dates back to 2020, all the year of 2023, and the whole year of 2000, and this year. So this has been going on for some time. And I don't know if you did get that declaration statement.
I've had a chance to review everything.
I can go over the dates and times if you'd like of every time. Oh, okay.
I've had a chance to review what you've submitted. Is there anything else you'd like me to consider, ma'am?
I guess just the incident over the weekend. That would be about it. Whatever happened over the weekend here.
All right. What do you want me to know about?
Well, the respondent, she basically spent intimidating me and using coercive control to make me feel afraid. And I talked to one of the neighbors, and he told me that if I follow through with this restraining order, there can be dire consequences. Then when I came home, my boyfriend told me that the respondent and her boyfriend been harassing him to sign something, and that if he didn't, then she would get a lawyer. And then on Sunday, I heard a knock on the door, and then the respondent's boyfriend was over there, not at the door, and I didn't answer the door. I just I didn't even open the door. I just didn't answer the door. And then when I looked at my video evidence over the weekend, I seen that the respondent is right in front of my camera right in view, and then taking a picture of my house. And that's what happened over the weekend. Now, that's all I can say, Your Honor. Thank you. And speak up for myself.
All right. Ms. Curtis.
So I have a really hard time explaining myself. I have anxiety.
All right. Thank you, Ms. Yell. Ms. Curtis, I'm going to turn to you. What would you like me to know about this matter?
Anxiety leads to constipation.
You know where to start. So I've not talked to this lady. The last time I talked to her was when she came over to my house, I think January, in the middle of the night, screaming at me and my boyfriend about how we're stalking her or something. That was the last time I ever even said any words to her at all. I don't even talk to her. I purposely avoid her and don't even look at her house when I go outside for this purpose right here, because I know she does this stuff when, I don't know, manic episode, whatever it is. I have cameras around my house, 24/7 surveillance for this reason specifically. And I know she has cameras too. So thank God she has cameras, because any of the accusations she's made should be on camera, right? Like there would be some evidence of them. There's nothing. I don't even talk to her. I don't have time for this. I work 2 jobs. I'm hardly ever home. And I'm going to move now because of this situation. This is causing me a lot of grief and unnecessary. It's just, I don't have any reason to steal her Wi-Fi. I have my own Wi-Fi. That's ridiculous. I don't know. I've never said a word to her ever purposely. I don't even look at her. I don't even really know what else to say. I don't have time for this. It's been going on, and it's an ongoing thing with her for quite a while now. And the accusations she makes about I put something in her boyfriend's drink and asked him for money. I've never been late on my rent one time ever in life. I don't have any complaints with my landlord or any other neighbors. And she thought that me and her boyfriend had some sort of weird affair thing shortly after I moved in, and that's what spiked this whole thing. That her boyfriend, because he lives on this side, she lives on this side. Her boyfriend told my boyfriend that she thought we were sleeping together. Some crazy.
Can I say the words that she said, or?
Sure. I need for you to tell me what went on.
That I'm not on that whole shit. I'm not with that whole shit.
And that's what started the whole ordeal.
Got it.
Okay.
All right. Thank you, Ms. Curtis. I think I understand what's going on here. Based off of the statements of both parties and the files in the record, I'm going to deny this request for a protection order. I don't believe that there is sufficient evidentiary basis to do so. And based off of the testimony of both parties, I don't believe that there is reason to issue a protection order. So I'm going to deny this order. That will conclude this hearing. If either of you need a copy of this paperwork, it will be available through the court website. Call the court if you have any questions. That will conclude today's hearing. Otherwise, I have no appearances from any other parties on my hearing calendar. So this will conclude Thurston County District Court. If you're watching at home, have a good day. And I just need a brief
over while the criminal matter was pending, so we're still trying to get all the documentation in.
Okay, but just if I can follow up on that, the stay that was issued, Judge White had issued one back in.
Okay, so this is the Karen Reed. Now we're in the civil action. She got out of the criminal charge, but they filed a civil case, and we're talking about that.
Maybe the fall, I had issued one when the criminal trial was ongoing. That was sort of a self-defining 60-day or whichever.
And now you'll see why I never do civil cases.
Whatever comes first. So that should be pretty much in the rearview mirror for now, right?
I recognize that, Your Honor. Right. So when the stay was lifted, all discovery was served on the parties or thereabouts.
Wrongful death, I guess.
We're talking about depositions, documents, notices of depositions, or no?
Only one deposition has been noticed, and it's been tabled because we don't have any documents at this stage.
I see. Okay, so it's really the paper discovery that you're looking for. And when you say the DA's office, that obviously is not the defendants, that's going in a different direction, but you're pursuing that sort of on your own?
I am.
Right, but I anticipate that the defendants have all the same data that was exchanged during the criminal matter, to which we haven't ever received. So we have requested that both from the defendant and we've requested it from the DA's office.
Okay.
It is coming in from the DA's office in parts, and I anticipate we should have it all within the next 21 days, is my guess.
Okay. All right, procedural issues from the defendants. We can start with you, Attorney Seligson.
Thank you, Your Honor. As we're anticipating the status of this case, it's important to inform the court that from Ms. Reed's perspective, we have affirmative claims that we intend to bring on her behalf. Those claims stem from the same facts that are at issue in this case. Those claims, Your Honor, are against parties that are not in the litigation at this point, including the Massachusetts State Police, Lieutenant Brian Tully in his personal capacity.
Oh, good Lord.
Sergeant Yuri Buchanan in his personal capacity, Michael Proctor. Those claims would be in the nature of violations of Karen Reed's civil rights and conspiracy. The claims against the Massachusetts State Police would be negligent training, supervision, and retention.
Oh yeah, good Lord, this is going to be a freaking mess. So they're not filing a counterclaim. They're filing. They're bringing in other parties, which will make it a 1983 claim and probably get it removed to federal court. I warned you people. You don't want to think about this stuff.
Of Massachusetts State Police troopers. We also intend, Your Honor, to bring claims, affirmative claims, against Brian Albert, Nicole Albert, Matthew McCabe, Jennifer McCabe, and Brian Higgins, who were the occupants of 34 Fairview Road in Canton on the night in question. Those claims will be in the nature of civil conspiracy, violation of Karen Reed's civil rights, and then a claim against the town of Canton through its police department for negligent failure to secure the garage in the Sally Port. We asking the court's permission to bring those claims in this case because.
Oh, good Lord. He's asking for leave to file these claims. And then literally my guess is to try to get it into federal court, which would be better for the defense. And then there will be a motion to sever the claims. Oh, sweet Jesus. Here we go.
They do arise out of the same nucleus of operative facts. In order for us to fairly defend Ms. Reed in this case, those claims, those parties need to be asserted in this case. What we'd like to ask the court's indulgence for is we have a proposal of how to bring those claims in, given the voluminous nature of this case. That would be 10 additional parties coming in. To do that, we would be alleging that the individuals in the House diverted attention away from themselves towards Ms. Reed, that law enforcement then acting on that diverted attention away from her, because the people in the House were either police or police adjacent.
Okay, so all of you who say, oh, we want to see you in court. We want to see you in court. It'll be so fun and exciting. This is what it looks like. This is what it looks like, what I do all day. Okay?
Who are socially and personally connected. Then they collectively conspired to ensure that what happened in the House was not explored and investigated. And instead, Ms. Reed was wrongfully targeted, maliciously prosecuted, made to face 2 criminal trials for the death of John O'Keefe, and is now facing allegations of wrongful death, all stemming from the same claims. How do we synthesize the process to bring these claims and parties in? What we're asking the court to consider is for us, at the time we file her answer to the complaint,
thank you.
We've got some claims that we're asking to be dismissed, regardless of how the court decides those. We still have to file an answer on her behalf. Our suggestion would be to file those claims against those parties in the same pleading. Serve all of those new parties with that complaint. Allow them 30 days, not the normal 20 days, to respond so the court can have one hearing on whether some may bring dispositive motions, some may file general answers, so that we can then decide how and who is in the case and proceed forward. So I bring that to the court's attention. And I'm happy to brief it so that Mr. Diller can have an opportunity.
Well, at a minimum, you're going to do that. I'm envisioning what the plaintiffs are going to say to this rather extraordinary process, but go ahead.
But that would be, otherwise it's going to be a very unwieldy, delay-inducing process, and we're not looking to do that. This accounts for trying to conserve judicial resources, trying to have a streamlined approach, at the same time making sure that all the claims and all the parties are in this case. The alternative would be for us to file a separate action on Ms. Reed's behalf, alleging these claims, and then move to consolidate immediately with this case, which Your Honor has broad discretion to allow. The point being, the claim should be in this case. They all arrive out of the same facts. They're not separate. And that's essentially what we'd like to do. We'd like to brief that, Your Honor, and have the plaintiffs respond and then proceed.
How this proceeds is entirely in the judge's discretion. Entirely.
From there.
Okay. All right. Let's hear it then from the Waterfall.
Yes, Your Honor. We are in the process of completing written discovery propounded to us from the plaintiff for order of extension until next month. We anticipate that will be completed then. We as well.
When you say an extension, this is an agreed to extension? Because the tracking order is what it is. We'll get to that in a little bit.
It's been agreed to, Your Honor.
Okay.
And then, Your Honor, we're looking at depositions, but we don't want to consider noticing depositions yet until a lot of the document requests have been answered in the subpoenas for keeper of records. We haven't seen any of the records. We're aware of them certainly from the criminal trial, but when there are a lot of records, as I understand it, that are still to be produced, so that we would then proceed with depositions as warranted in conjunction with counsel and obviously picking dates that work for all. But that's what we foresee in the immediate future, Your Honor.
All right, thank you. Let's hear from C.F. McCarthy, son.
Your Honor, on a similar vote as to Waterfall.
If you're representing the estate here, the plaintiff's attorney, you want these claims separated all day long. You just want a clean shot at your wrongful death claim without all this other nonsense in it. You may or may not get it. The judge may decide it's in the just interest of judicial economy to deal with it all at once, or they may not. But it's clear to me what the strategy is on both sides.
Inefficient touches on our discovery responses. The last leg of it is just direct communications from employees thematic the incident, some of whom no longer work for C.F. McCarthy's, but we anticipate having that completed in the very short term and getting that over to my brothers.
Okay. All right, thank you. Let's hear from the plaintiffs then in terms of the response to the procedural issue that was raised in particular by Ms. Reed's counsel. Are you aware of the circumstances that they're seeking to join 10 additional defendants into this action?
Absolutely not, Your Honor.
It's the first notice you've gotten?
Of course, I would expect
Not how the court system likes this stuff to work, folks.
Right, I would expect the courtesy of a meet and confer to at least let me know. Obviously, they can choose not to do so. That's their prerogative, but I certainly would have liked to have been made aware. Section 1983 actions, I believe, Your Honor, would have to go up through the federal court. We're not seeking to have this case removed in the federal court. We started in the state court.
It's almost like I've done this before.
We're intending to move forward in the state court. We would like to have a state court Plymouth jury decide this case. So to the extent that my brothers and sisters and all of those who are involved believe that they have other legal rights and they want to pursue other legal theories, that's their prerogative to do so. When it comes to interfering with our opportunity and right to justice, we're not looking to sideline that, Your Honor.
All right. Any response, counsel?
Thank you, Your Honor. We are asking for permission to serve a motion to advance this procedural proposal, so Mr. Diller is not being surprised by the argument that we're going to present to the court, he will have an opportunity to respond. There's no requirement that civil rights claims be brought in federal court. In fact, this court has jurisdiction over those claims. They all stem from the same facts, Your Honor. In the plaintiff's complaint, there are allegations that we need those parties to defend against. This is not just a wrongful death action. Our narrative of what took place.
But it is, though. It's the plaintiffs. Well, just hear me out for a second. When you say that it's not just a wrongful death, that's what the plaintiffs have alleged. The defendants have filed motions to dismiss portions of those. So this, at its essence, is a wrongful death action being brought by the plaintiffs, right? So what you're seeking to do is to be allowed to amend these proceedings and to effectively bring in 10 other defendants for the claims that the defendants have against those third parties that aren't noticed here, right? So you've got to procedurally give them notice as well as the plaintiffs notice of this event before it goes to any adjudication by the court.
And that's what we've built into this proposal, which is trying to streamline that process, not depriving them, the new parties, of the opportunity to argue both the procedure as well as the substance. And we're suggesting, instead of serving party X with a third party motion for a complaint, then that party opposes it, then the court rules, then that party perhaps is brought into the case and then brings another motion to dismiss substantively. We're not seeking to...
Isn't that what the rule requires?
The rule does require that, but the court has discretion to consider the streamlined approach, and we'd like to brief that for Your Honor, but we're raising it at the status conference so that, because we are scheduling deadlines and events out into the future, we'd like to at least have the opportunity to advance that argument for the court and allow Mr. Diller to respond to it, and then we will act accordingly. That's the purpose of the disclosure of this today, Your Honor.
All right, so I don't know that there's any ruling by the court today that would have to be made relative to that, because it isn't even filed yet, so that there's nothing before the court. So ideally, what my instructions to the clerk's office by setting this event up was to get a trial date from you folks and then work backwards, like we would do with any wrongful death tort action, which this case is. I take exception to the defendant's notion that this is not just a tort action. It is. That's what it is. It's a civil case. I know there's a lot of people who are interested in this case, but at its heart, there are at this time eight parties involved in this case, correct?
Yes,
there's 5 for the plaintiff, and there's 3 for the defendants, 2 corporations and Ms. Reed. So that's the way the case is shaping up. You've got your tracking order, so you understand what the deadlines are now. I have the tracking order, I think, basically shows this case as having discovery. Yeah, your discovery is supposed to close August of next year. Your Rule 56 motions to be done by October-ish of next year. Final pretrial conference February of 2027 with judgment by August 26th of 2027. So that's what the tracking order has in store as the case stands now, right? I mean, we could get you a trial date way sooner than that if you wanted to. I mean, literally, I could, the clerk and I were talking earlier before today's proceeding, and I may end up having to suspend, depending on what the circumstances. We were charging the jury on a homicide case earlier today. So we have a deliberating jury right now, so I don't know that I may have to suspend and then rejoin here in a little bit. But for now, so you understand it, we could get you a trial date as soon as practically this spring on this case. But to join 10 new defendants under wholly separate theories for people that haven't even been joined yet in this litigation puts that on its head. There's no way you wouldn't even have this procedural process outlined by the spring, most likely.
I understand that, and that's the dilemma that we're trying to bring to the court's attention, because there is going to be an affirmative pursuit.
Well, you're saying you said earlier affirmative defense in this case, which those would not be affirmative defenses. Those are wholly separate third-party causes of action against people who are not part of this litigation, correct? So it's not an affirmative defense.
It's not an affirmative defense in the traditional sense, but it is part of the defense in the face of the wrongful death claims. The wrongful death claims stem from the same facts that the affirmative claims would be seeking to be pursued against. So it is the same set of facts. If we were to file a separate action, Your Honor, where Karen Reed is the plaintiff and these parties that I've identified are the defendants, we would be pursuing down two separate pieces of behemoth litigation when we can consolidate them at the same time. That's what we're trying to suggest may be a more streamlined approach. And it's not intended to delay. It's actually intended to try and synthesize the process and conserve resources, attain judicial economy.
Oh, it's intended to screw up the wrongful death claim, which is good strategy. And of course, he's couching it in judicial economy, which is the right argument. The judge is sharp. The judge knows what the hell's going on. Saw it all immediately. All these, both attorneys and the judge are sharp.
Without prejudicing the plaintiff. Discovery's already ongoing. But to have two depositions, for example, of parties in two separate cases, where we can have one and the claims could proceed at the same time, just seems to make judicial sense. That's why we're raising it. But we'd like to brief it if the court gives us that permission.
Okay. All right. On that last discrete issue, anything else from the plaintiffs?
We have served them with discovery, asking them, they have a burden if they're going to do affirmative defenses to establish that there are third parties who are responsible here. That can be their affirmative defense, but they have a burden to prove that. And if they can't meet that burden, then it should never come into our case. If they're seeking to overlap these two cases and throw it as far wide-ranging as they just announced, then there's no way that we would not be prejudiced by their strategy in the plaintiff's underlying case.
All right, those issues are reserved. I'm certainly not going to make any ruling on that. There's nothing formally before the court, no written motion, no Rule 9A or 9C certificate, none of that stuff. So it's not procedurally before the court, but certainly I appreciate hearing the argument nonetheless that this may be the future landscape of the case. What also brings us here, when I noticed the status conference for today, the defendants have filed motions to dismiss. If you're prepared, I'll go forward on that, let you deal with the substance of the motions to dismiss. I have read through your material, so I get the gist of what the defendants are raising. Counsel, would you like to proceed?
Thank you, Your Honor. As we've briefed, Your Honor, the counts that are at issue in the motion to dismiss are counts 13, the counts 10 through 13. They are infliction of emotional distress claims. As we have presented in our papers, none of the plaintiffs observed the alleged incident that is described in the complaint. None of the plaintiffs came upon the decedent in close enough proximity to state a claim for emotional distress. There is the cases, Your Honor, limit when a claimant can claim emotional distress. The cases talk about temporal, spatial, and relational limitations. Taking the claim that Kaylee Ferb.
Oh, sweet Jesus. This is the same in Illinois, pretty much. Pretty much, you have to be in what they call the zone of danger. That's the same concept he's talking about. I told you, civil law sucks.
Bush has alleged. That claim is for negligence / reckless
I'm kind of enjoying this.
/ intentional infliction of emotional distress. And the basis of that claim is that there was a discussion on the telephone or discussion after Karen Reed had left 34 Fairview in Canton and had somehow started to fabricate a story about what had taken place.
Had a lot of people to feed.
Was not at the scene, and the perception of someone dying is not an actionable claim under any case that we can find in Massachusetts state law. So she wasn't at the scene, didn't come upon the decedent, and therefore doesn't have the same types of proof, at least is played in the complaint, that would satisfy the limitations that the case law sets out, the temporal, the spatial, and the relational. With respect to the
I got a Sarah Boone update if you guys are interested.
claims of emotional distress that have been brought by John O'Keefe's mother, father, and brother, again, they were not witnesses to the event. They came upon him many hours later. There are cases, and particularly the Cohen case that is cited in our brief, that speaks to the time that passes between an alleged event and when a family member or a bystander witnesses the consequences of that alleged event. And in that Cohen case, the court speaks to the fact that the mother of a young man that died in a plane crash didn't get to find out about it until many, many, many hours later, and the court denied the right to pursue an emotional distress claim. More importantly, Your Honor, there is a remedy here. If for the sake of argument, there is a remedy here through the wrongful death statute. And the wrongful death statute compensates for the types of harms that are alleged in the complaint. So what we're asking the court to do is to dismiss out the emotional distress claims because they are duplicative and allow the plaintiffs to pursue the wrongful death action singularly. We rest on our papers. Thank you, Judge.
Right, thank you. So let's turn to the other defendants, if they want to be heard. You've filed separate motions, essentially arguing the same relief, but if you have anything you want to add, you certainly can. The Waterfall?
Yes, Your Honor. We have the Waterfall just very briefly. I think the distinction here that counsel's making is that these claims, these infliction of emotional distress claims are intended when you're in the zone of danger or you're a recipient witness. And in this instance, it's many, many hours later that the parents are seeing the decedent in the hospital. I think it's after 7:50 a.m. And so based on what the Cohen case states and in terms of the principles that the courts have applied here, it just isn't, from a relational standpoint, close enough in proximity to be able to advance this type of claim. And in terms of the wrongful death statute, those loss of consortium damages, the damages of the loss of a son, if the plaintiff is making this claim going forward, are in fact addressed in that statute. And obviously...
Okay, I've tortured you all enough. I want you to know that I've only done a third of this hearing. It's going to go on and on like that. But that's the update on the Karen Reed situation. They've got months of motions in front of them. Months. And this thing will never see a trial, if I had to guess. It's unlikely. It's not never. It's possible, but I think this thing settles out eventually. All right. Let me see what I got here. Oh, wait a second. Just a second. I don't have Boone ready yet. We'll let it play for a minute while I get Boone ready.
Would be available as remedies to the plaintiff.
What about Semino versus Milford Keg Incorporated? I have a 1982 case that I found talking about the wrongful death, emotional distress injuries. Have you reviewed that case? I'll give this case site, 385 Mass 323. It's a 1982 case. So it would seem to suggest that that emotional distress is really not preempted by the wrongful death statute.
Your Honor, I think the wrongful death statute alone would not necessarily cover all of the damages, but my argument would be more in line with the argument that in terms of where they are in relationship to the accident, since it wasn't witnessed.
Has been truthful and ethical and providing the proper paperwork in a proper amount of time so I can actually review and correspond timely with the correct information.
Ms. Boone, you're way off base here. I need to know an opening statement is kind of a outline of what you intend to present at trial on the issues regarding the parenting plan proposed for the...
Okay, this was sent to me by Lucificence Lair, but it's from a channel called SKR. I don't know. It's got a lot of their stuff in there, but this is the only copy of this stuff that I've seen. So big shout out to SKR.
The relocation and the modification of alimony and child support.
Consent also included at some point?
No, ma'am, I've already dealt with the motion for contempt dealing with the application. Again, I told you what the issues were that we're here on today. You may continue, but let's talk about those issues. What do you intend to present as your evidence and your position regarding the relocation proposed parenting plan and the modification of child support, the modification of alimony, and the request for sole parental responsibility?
Sarah Boone.
Those are the issues that we're dealing with right now. And what's the relevance to the issues that we're here on today, which is the relocation proposed parenting plan and the request to modify either child support's not an issue, but to modify alimony?
This is where I'm unclear, Your Honor. I'm not sure what exactly I'm supposed to be doing. Is this in regard to the parenting plan for the relocation?
I've explained to you more than one time the issues that the court is considering today. You need to be asking questions regarding those issues. I will say them one final time. The issues are the petitioner's proposed parenting plan that was filed in relation to the petition for relocation, and then the request to stop alimony. And there's also a request for attorney fees. Those are the issues the court is considering. Those are the issues that you should be asking questions about.
I had no idea that the relocation parenting plan was even an issue, considering the fact it's been agreed upon.
I'm not sure why you have no idea when I've said it. I think this is the 5th time.
Yeah, double homicide. Homicide.
Bitch.
No, I'm sorry.
5th time that I've said it.
Forgive me, Your Honor.
Sorry, Miss Jackson.
For page 2 of the relocation with the parenting plan, it says that it will dramatically improve the economic circumstances of the petitioner and the minor child.
So I'm going to object because as the relevance, because.
All right, I'm going to sustain the objection. Again, ask questions regarding the issues that I just gave you. We've already stipulated, you've already agreed to the relocation to. Okay, so the only issue with regard to relocation is the proposed parenting plan.
And that is what she is not getting.
I'm not sure what I'm supposed to do. And am I supposed to object to it? Because I object to it.
Right. We're here for a final hearing. Whether or not you object to it is not relevant at this time. The court is going to make a decision based on the evidence that is presented today. The court's question for you: do you have any additional questions for Mr. Boone regarding the proposed parenting plan, the request that the alimony be discontinued, or the request that the child support be discontinued, or the request for attorney fees?
If you could just give me a moment, please.
Okay.
Forgive me, I don't know what I'm supposed to be doing with this relocation. Communicating with you about our son?
Yes.
Have you responded?
You've already been over this. Next question.
Modify? That's what I'm trying to do.
When the parents plan remains in effect until further order of the court.
Ma'am, you're beyond the issues we're here on today, okay? Next question on those issues that I've gone over with you over and over again.
Forgive me, I'm trying to do my best without knowing what I'm doing. For the objection to relocate, how soon before the actual relocation did you tell me?
All right, again, that's not relevant to the issues we're here on today. The relocation to has already been determined, okay? Specific questions regarding the proposed parenting plan that was admitted into evidence as Exhibit 1, the request to stop the child support, the request to stop the alimony, and the request for attorney fees. Do you have any questions, any additional questions on any of those issues?
Yes, Your Honor.
No, God! No, God, please, no! 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 No!
I don't know if you can answer this or not. I just don't know without asking you. Are my questions after this? Is that the end of it? I mean, I don't know how much further this goes for me to be able to utilize my pretrial statement information.
This is bad.
All right, as I explained to you at the beginning of this process, I will do it again. The petitioner has the burden in this case.
I mean, they're trying to cut off child support. She's in prison. She doesn't get child support. There's like, I don't know why she gets to say anything, why she still has rights of any kind. I'm no expert on the topic. This is not something I do. But, you know, my overwhelming sense is she's going to lose everything no matter what. It's just, we're just going through the process.
They get to call the witnesses. They get to introduce evidence. Okay. Once they are done, then I turn it over to you so that you can call any witnesses or you can provide any documents that you want the court to consider. I also want to say to you, it is now 3:06 p.m. We will not be going past 5 o'clock. So the more you continue to ask questions that are not on the issue that we've talked about today, the less time you will have to present your case. Okay?
Yes, Your Honor.
All right. And again, I'm going to say to you again, the topics we're here on today is the proposed parenting plan that was admitted into evidence as petitioner's exhibit number 1 that was pre-marked as G in the packet of materials that you received, as well as the request to have the alimony of $1,000 per month discontinued and the issue of child support of $100 per month discontinued and the request for attorney fees. Those are the only issues the court is considering today. Those are the only issues that you will be permitted to provide evidence on at this time. Okay?
Forgive me, it's Exhibit D, the proposed amended parenting plan, the attorney fees, and what was the last?
The request to discontinue alimony and the request to discontinue child support, which I think you said you agree that he should not be paying child support as of February of 2020.
Okay. So parenting plan, attorney fees, and alimony.
Correct.
Okay. 2018, I believe, I wanted to bring to the court's attention that it's been violated by the petitioner. Again, from previously, now I believe it's a time where it says the parenting plan may be modified or verified on a temporary basis when both parents agree in writing.
All right, Ms. Boone, you have to agree that there's a lot that's not being followed with regard to that parenting plan, which includes even the time sharing that you're not able to do at this time.
Right.
You would agree with that, correct?
I understand that, but that is my only stipulation. That's my only part that
All right, you would also agree that that parenting plan was entered into back in 2018 prior to there being any criminal charges in your incarceration. Do you agree with that?
I do, Your Honor.
Yeah, double homicide.
But
okay, and you have to also agree that when the parenting plan was entered into, if I remember correctly, you all agreed to the parenting plan as part of your mediated settlement agreement back in 2018. And at that time, neither one of you were contemplating any type of criminal charges,
Double homicide.
or incarceration. Is that correct?
Yes, Your Honor.
Yeah.
Okay. All right, you may continue. Any additional evidence you want the court to consider?
In regard to the parenting plan,
In regards to any of the issues that we're here on today that I have recited over and over, I think I might be on time number 7 now.
double homicide. In regard to the alimony, I would like please to 2.
All right, that is not a citation for a case named Lamb.
Lamb versus Lamb.
All right, and I need you, how many more of these you have? We were down in 15 minutes and I gotta give counsel an opportunity to question you and then save time for closing arguments.
I'm not sure. That's why being on the phone is very difficult. I'm sorry. I'm doing everything that I possibly can to properly represent myself.
Cute rehearsed line, but no, you aren't.
Ms. Boone, did you have any other evidence that you wanted the court to consider?
Yes, I did. I had some other exhibits that I would like to have put into my evidence, and then I also was supposed to speak about the attorney's fees.
Then why didn't you do that? You have been sitting here for hours and hours and hours saying, I don't want one 30-minute phone call. I have so much to offer. I am my son's only mother. Brian doesn't include me. He says he doesn't care. He's so mean. I need my money, this and that. You have had nothing but hours to get through stuff. And now that you're about to get dragged out of the courtroom by your uniform while still trying to speak,
and me being pulled by my uniform to exit your courtroom while still trying to speak.
Now you can rattle off exactly what you need to talk about. Well, I had all these exhibits to get in, and then I had to talk about attorney's fees.
I've given you lots of time to speak about all the issues. The fact that you didn't take that opportunity instead of going into other issues is not what the court is going to address now. What specific exhibits do you would like to move into evidence?
Your Honor, forgive me, but I'm here on the phone trying to do all of this.
Forgive me when I ask you what other exhibits that you want to put into evidence.
Yeah. Double homicide.
Bon appetit.
Oh, Miss Jackson.
Miss Jackson.
Has had it. Wow, that is incredible. Because that's what she does. She always tries to, well, it's not my fault, it's this. Well, excuse me, I'm on the telephone. Excuse me. Tell me if you have any other useless exhibits to enter. Let's speak now or forever hold your peace. Yeah, it can't be any clearer how bad you lost this.
My number 10.
Next.
That's all I have for right now, Your Honor. I'm being rushed out.
All right, I'm going to give you all until next Monday at 5. I'm going to say by 5 p.m. That includes, Ms. Boone, you need to put it in the mail by next Monday, a written closing argument on the issues we're here on today, okay? So I'm going to give you all until 1 week to provide written closing arguments, no more than 5 pages.
No more than 5 pages?
That is correct.
Parenting plan, alimony, attorney's fees. Please, if I may, before we hang up, the closing arguments are for parenting plan, alimony, attorney's fees, and...
I am not repeating myself, ma'am.
Yeah. Double homicide.
You need to make a closing statement. You need to put it in the mail to me no later than next Monday, which I believe, actually, that's a holiday. So I'm going to give you all till Tuesday, which is September 2nd. I will not accept anything that is postmarked beyond September 2nd. Again, this is closing arguments on the issues we're here on in trial today. No more than 5 pages. Thank you and have a great day. on the issues regarding the parenting plan proposed for the relocation and the modification of alimony and child support. The relocation proposed parenting plan and the modification of child support, the modification of alimony, and the request for sole parental responsibility. The relocation proposed parenting plan and the request to modify either child support's not an issue, but to modify alimony. I will say them one final time. The issues are the petitioner's proposed parenting plan and then the request to stop alimony. And there's also a request for attorney fees. So the only issue with regard to relocation is the proposed parenting plan. Regarding the proposed parenting plan, the request that the alimony be discontinued or the request that the child support be discontinued or the request for attorney fees. Regarding the proposed parenting plan, the request to stop the child support, the request to stop the alimony, and the request for attorney fees is the proposed parenting plan, as well as the request to have the alimony of $1,000 per month discontinued, and the issue of child support and the request for attorney fees. The request to discontinue alimony and the request to discontinue child support. In regards to any of the issues that we're here on today that I have recited over and over, I think I might be on time number 7 now.
There you have it. There you have it. It was a wild ride. I had all sorts of crazy stuff. I had all sorts of crazy stuff. It was ladies' night, but then I had 2 add-ons during the stream. But it was still ladies, so it was still ladies' night. Who do we have in here? We got to visit Vallow Daybell. We got to check in on Karen Reed. I'm sorry, but this everyone's asking about that. So that's the practice of civil law. It's boring as hell. It's boring as hell. And complicated. That's the way it goes. And then we get Sarah Boone rolling in here. I mean, what's the point of this? She's in prison for life because she's a killer. This is a 2-inch putt. She doesn't get any alimony. She doesn't get any child support. And the parenting plan is modified to take her out of it. Period. End of statement. I don't know. We don't have the ruling, but can there be any other ruling? Is there any other possible ruling? The answer is no, there isn't. Thank you all for coming out. That was a weird one. I will see y'all soon.